for those of you who are here for the first time and may not know, let me just tell you a little bit about why we're here. This lecture series honors John Gedid, one of the founders of the Harrisburg campus. He was the first vice dean of this campus, and who has subsequently served as a wonderful, wonderful mentor to every faculty member of the school has hired. So for those of you, my students in the audience, mentoring takes place not only among teacher and student, but it continues, as it should, throughout your career. So take advantage of the wonderful mentors you have here. And because of his leadership, John, we can't thank you enough for what you've done through the years. And I know that a lot of that is possible because of your wonderful spouse, Carol, who is here with you today. Thank you, Carol, for coming. And for those of you who don't know, I don't know if there's anybody in the audience who doesn't know, they are grandparents again. Just this week or Saturday, a young man, James Andrew, weighing in at 6 pounds and 10 ounces. And premature. So that's going to be a big boy. So we thank you for all that you've done in so many ways, John and Carol.
Dealing with immigration, necessarily and intrinsically, you're dealing with foreign policy and national security, and that has to be done at the federal level. One of the sort of problems in practice with state efforts to regulate immigration has been that they often do so, they're often moved to do so when they're angry about something, when they're upset at the behavior or conduct of another country, and that doesn't bode well for sort of measured, appropriate legislation. One of the big cases comes from 1876 in California, a case called Chilong versus Freeman, where California was trying to prevent Chinese from immigrating to the state. It wasn't legal or illegal under federal law in 1876, because in 1876 there was really no general feds that states and localities are impliedly authorized to pass laws and ordinances that mirror federal guidelines. The brief for 80 U.S. senators and representatives supporting the constitutionality of SB 1070 said, Congress has passed numerous acts that welcome state involvement in immigration control. And so far as it goes, that authority is right. What Professor Kovach and what the senators and representatives say is true. The cases and statutes exist. The problem is that they all involve arrests. The cases involve states helping the federal government by arresting for immigration crimes. The various provisions of the Immigration and Nationality Act authorize state and local officers to make arrests for criminal immigration violations. And what Professor Kovach and other defenders say is that this suggests that there's an implied invitation on the part of the states and localities to legislate. And so the issue is whether state power to arrest for criminal immigration violations, which clearly exists to some extent, implies state power to legislate. And I argue that it does not. I think there are a number of examples in the law where entities have the authority and power to arrest, where it's clear that they don't have legislative authority. One example is citizen's arrest. Every person in most jurisdictions in the United States can make an arrest, at least for a felony, if the crime actually occurred and if there's probable cause, but that certainly doesn't imply that private citizens have legislative authority over other people. Another example is the National Crime Information Center, which is a computer database where warrants from all around the country are filed in such a way that a traffic stop, for example, in any part of the country will reveal an arrest warrant across the whole country.